to what they actually, to the consideration paid.
Yeah.
So when we have these homes that have been bought and sold at a discount, the loans have been bought and sold at a discount on the securitized market, they now can't come in and say the full value of the note. They have to start where they paid consideration and go from that point.
And this is starting from loans purchased when?
It doesn't matter, because the basis of the deficiency judgment is how this law kicks in. So even if they bought a loan on the securitized market in 2007 at a discount, when they go to foreclose, the measure of that deficiency is what they paid for that note.
Goodness.
So
I think the statute suggested that before. I think
correct.
that there was some language in the statute that would justify that you're not going to be able to recover more than you pay for a loan, even though when that loan was in force, there was a lot more owed on it than you actually paid for it.
Right. So what now it's going to read is Section 2 and Section 5, or actually Section 5 I think is the most expressive. It says
NRS
40.459 Section 5.
There you go.
It provides that the creditor may not receive an amount which exceeds the lesser of the consideration paid for the obligation minus the fair market value of the property at the time of the foreclosure sale with interest from the date of the judgment or of the sale and with reasonable costs, or the consideration paid for the obligation minus the amount for which the property actually sold at auction. So I think
that down for the common man.
To keep it simple, when the house sells at auction at 85% of fair market value, that's what it actually sold for at auction. That would be the amount of money that they could show they received a value for after your foreclosure sale completed. From that point, the only amount they could seek in deficiency, it would be the difference between that number and what they paid for the note. And we know that these notes are being sold for pennies on the dollar sometimes, depending on what loan pool they're in. So let's say house was $100,000 and at purchase, the note sold for $50,000. It goes at auction for $50,000. There's no deficiency. There's none. So
even though the amount of the loan was, or the balance due on the loan was $150,000.
Correct, because I think, and I agree, from the legislative perspective, is what's your losses? I mean, granted, you didn't get the benefit you were hoping to get, but that's the risk of buying a securitized instrument on the on
the open market.
Exactly. So there's the point of, well, no, I bought that note and leveraged my risk of being able to collect on it based on the face value of it. I should be able to collect the full amount, and that's what the lenders have been doing. But what our government has said here in the state of Nevada is no.
Go ahead and
you're not going to double dip on our citizens.
Our consumers.
It's not going to happen here.
Go ahead and go after your collateral.
Right.
And try to make your money that way.
Correct. So now, after foreclosure, if they're going to cash in on insurance and or they bought the debt at a significantly reduced rate, there's a lot of instances where they're not going to be able to pursue a deficiency.
This is just residential, right? It looks like we have another, but this is just for residential properties. It's not for commercial properties, or is it for?
Correct. Right now, the changes have been limited to just the residential properties. I think some of this may play into the commercial lending. We still haven't seen the bottom of the market there, so maybe as that becomes more of a pressing issue, the next legislative session, maybe they'll see how this works and tackle it. But I think this is also going to have a chilling effect because, the lenders are taking a gamble when they pursue a deficiency that person has, garnishable wages or has some type of asset to go after. So they're gambling at that. I think this will have a huge chilling effect on deficiency pursuits because I think what you'll see most of is if there's any alleged deficiency, I think it'll be actual debt collectors that buy it for a penny on the dollar because the risk is so high that you'll be able to collect on it. I think those are the only times we're going to see these pursuits now because the time frame is so short. And with the limitations of what indebtedness is, I don't think there's going to be much that the lenders can go after.
And the lenders' plates are so full.
Exactly.
And they can't just go after everybody. But here's another question from RC.
Okay.
Are there banks who make it harder to get a deficiency? I think he meant a deficiency waiver. Are there banks who make it harder to get a deficiency waiver than other banks? So sure, yeah, some
Absolutely.
banks are much more difficult to negotiate with than others, and I don't know if we really want to name names, but we're just, in our opinion, yes, there are certain banks, and I think that from my experience, the banks and the lenders who are more tough on these things are the smaller banks. And the smaller banks have kind of more invested in their borrowers and their borrowers' creditworthiness rather than the value of the collateral that hopefully secures their loan.
Right.
But I think the other thing is that it's easier for banks, and maybe banks, smaller banks, are a little bit more strapped than other banks. It's easier for them to pursue deficiency, to have their lawyers go after deficiency because maybe their plates aren't as full. They're smaller lenders. I don't know. But typically it seems that the smaller banks and lenders have been the ones who've been more inclined to pursue deficiencies than the larger banks. That's my experience. I don't know about you.
Yeah, it just depends. A lot of it just comes down to the negotiator that you're dealing with and who you're assigned to. I have had an easy time getting a deficiency waiver in a bank, and then on the next transaction pull teeth when it should be very obvious. There's a lot of behind the scenes motivations for what will be approved and what won't. So it's difficult to say. It's really difficult to say which banks are specifically going to wheel and deal, because there's so many things behind the scenes on that particular loan that you don't know. Which pool it's in, which investor groups it's in.
Yeah.
The pooling and servicing agreement really dictates what the servicer can and can't do.
Yeah.
So if a deficiency waiver is written into that PSA as being something they're not allowed to offer, it has nothing to do with that bank being difficult in their servicing. It's that they're restricted by those investor guidelines. I think a lot of times, too, no is just an easier answer than yes. And rather than even look at their PSA, they just blanketly say no. And if you just ask again and say, well, send me a copy of the pooling and servicing agreement, they'll go, oh, God, that's a nightmare. I don't want to do that. Okay, fine, you can have your deficiency waiver.
Yeah.
So we've had that. Threatening bankruptcy works,
Yeah.
Especially with seconds. That's the easiest way to get a deficiency waiver is we threaten a Chapter 13. Because we can strip them off in a 13, they get nothing. So, there's a lot of different strategies and tactics that you use to try to get the negotiation to work. But I think a lot of times it's not specifically the bank's policies as much as it is the negotiator you're working with, their knowledge and competency, and their willingness to just get the deal done and understanding that you're serious about it. And we have real estate agents that come to us all the time saying that they're able to get deficiency waivers just with a quick letter.
Yeah.
And then there's other times where they come in going, oh my gosh, you have to help me, this negotiator is a nightmare. So, it just depends. I know that's a terrible answer and everyone hates it and it's so common in law, but it just depends.
Sometimes do you think a borrower, somebody who's trying to sell a house in a short sale, the owner of a house, I'm upside down, I want to short sale it, I want to go ahead and list it, and then they finally get around to their approval letter from their lender, and their lender may be a little bit vague about what they're going to do and not do in terms of waiver deficiency. How do you deal with that? Do you get them to clarify it, or you just want to not touch it? I mean, I think
it's a gamble, because sometimes if you go back and ask for the clarification, and this has come up recently, is you go back for the clarification. What I've found is you make it a phone call. And if you call them up and say, hey, this is a little vague, what do you mean by it? And if they say, oh, well, we're reserving our right, but they don't specifically say they're reserving your right, then you're better off leaving it how it is.
Yeah.
Because most of the time, once they've made that decision specifically, they're not going to reverse it, unless you can show a reason why they should. Sometimes when you say that, you'll get a clarification letter that says specifically that they're waiving their right. And ideally, that's the language you want in there.
Yep.
But sometimes, we know, you can go back to Contracts 101 from law school, that ambiguity is construed against the drafter. And since they're drafting the document, if they leave it vague and ambiguous, I don't think they have as strong of a claim in court, and that is a defense that you could raise if they did try to pursue you for deficiency was, hey, wait a minute, I never would have gone through with this transaction had I not relied on this vague statement as meaning that you weren't going to pursue me. So, obviously as lawyers, we love everything to be clear-cut and
black and
defined,
yeah.
But sometimes gray and ambiguity works in your favor.
We have another question.
Okay.
Matt is asking, does this apply, I assume he's talking about does this new legislation apply to non-owner occupied houses?
Yes, the law with regards to the deficiency and how it's pursued will apply to any real estate. It doesn't specifically say primary principal residence. It doesn't have any of that numerology.
Any residential real estate.
It just says real property. So
doesn't aren't we specifying we're talking about residential loans?
Yes, we are talking about residential loans. Yes, so we're talking about real property. There's nothing indicating that it's limited to just owner occupied or principal residence, with the exception of the changes to Section 3. Section 3, if you remember, the last legislative session back in 2009 limited deficiency pursuit to any home or any deed of trust that was recorded after October 1st, 2009. If it met the list of parameters, you can't seek a deficiency judgment at all. It's not even limited to the 6-month statute of limitations. You just can't do it. So what they have done is they went ahead and added into that section. The same will hold true for junior lien holders.
Yeah.
After July 1st of 2011, then any home that's secured by a first and a second, if a foreclosure happens, there's no right of deficiency. But that's only when it's your primary principal residence and owner occupied during the length of, it has to be a financial institution.
But going back to October of 2009, the legislation that was in effect then,
correct.
Any loans made to people to buy a home or to refinance a loan that was principally used to buy the home, I think those loans are not subject to deficiency either.
Right, if it happened after October 1st. And
of 2009.
Correct, and so that didn't change. What this was saying was that for any obligation that was secured by a deed of trust after October 1st, a court may not award a deficiency judgment if the creditor or beneficiary is a financial institution. That's number one. Number two, the real property is a single family dwelling.
Yep.
And the debtor or grantor was the owner of the property, so you got to be the owner. Number three, the debtor used the loan to purchase the property, so it can't be a cash out refi or something like that. It has to be for the purchase. 4 would be that the debtor occupied the property continuously after obtaining a loan, so you can't have used it as rental property. And they didn't refinance the loan during that time period. So loan modification I don't think would apply in this scenario. So if it's after October 1st, 2009 and you did do a loan mod, you're just modifying the terms of the note. You're not actually refinancing and or recording a new deed of trust. Although it's arguable, we don't have any case law on it, and I can see someone raising that issue saying, well, no, a loan modification is a refi with no refi costs. I mean, that could come up. But what this did basically was it elaborated on this change from October of 2009 to say that this applies not just to a first position, but also to a junior lien holder as well.
Good.
So that's the only thing that changed with regards to foreclosure law that really kind of parses out whether it's owner-occupied property.
But it does protect people who have left their properties, so non-owner occupied properties are included in this new legislation.
Yes, so the laws with regards to the